Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion in Jim Yovino, Fresno County Superintendent of Schools versus Eileen Rizo, on petition for writ of certiorari to United States Court of Appeals for the Ninth Circuit, decided February 25th, 2019. This is a per curiam opinion. The petition in this case presents the following question. May a federal court count the vote of a judge who dies before the decision is issued? A judge on the United States Court of Appeals for the Ninth Circuit, the Honorable Stephen Reinhardt, died on March 29th, 2018. But the Ninth Circuit counted his vote in cases decided after that date. There's actually a footnote here that bears reading. In Altera Court versus Commissioner, decided 4 months after Judge Reinhardt died, his vote was initially counted as one of the two judges in the majority. A footnote in the opinion stated Judge Reinhardt fully participated in this case and formally concurred in the majority opinion prior to his death. Later, however, the court vacated the opinion and issued an order reconstituting the panel. No similar action was taken in this case. Returning to the reading. In the present case, Judge Reinhardt was listed as the author of an en-banc decision issued on April 9th, 2018, 11 days after he passed away. By counting Judge Reinhardt's vote, the court deemed Judge Reinhardt's opinion to be a majority opinion, which means that it constitutes a precedent that all future Ninth Circuit panels must follow. See United States v. Caponera. Without Judge Reinhardt's vote, the opinion attributed to him would have been approved by only 5 of the 10 members of the en-banc panel, who were still living when the decision was filed. Although the other 5 living judges concurred in the judgment, they did so for different reasons. The upshot is that Judge Reinhardt's vote made a difference. Was that lawful? Eileen Rizo, an employee of the Fresno County Office of Education, brought suit against the superintendent of schools, claiming, among other things, that the county was violating the Equal Pay Act of 1963. The district court denied the county's motion for summary judgment, and the Ninth Circuit granted the county's petition for interlocutory review. A 3-judge panel of the Ninth Circuit vacated the decision of the district court based on a prior Ninth Circuit decision, Coba versus Allstate Insurance. That the panel believed it was compelled to follow. The court then granted en-banc review to clarify the law, including the vitality and effect of Cuba. Like other courts of appeals, the Ninth Circuit takes the position that a panel decision like that in Cuba can only be overruled by a decision of the en-banc court or this court. See Nerudo versus Slater. And therefore, a clear purpose of this en-banc decision issued on April 9th was to announce a new binding Ninth Circuit interpretation of the Equal Pay Act issue previously addressed in Cuba. The opinion authored by Judge Reinhardt and issued 11 days after his death purports to do that, but its status as a majority opinion of the en-banc court depends on counting Judge Reinhardt's vote. The opinions issued by the en-banc Ninth Circuit state that they were filed April 9th, 2018, and that they were entered on the court's docket on that date. A footnote at the beginning of the en-banc opinion writes, prior to his death, Judge Reinhardt fully participated in this case and authored this opinion. The majority opinion and all concurrences were final, and voting was completed by the en-banc court prior to his death. The Ninth Circuit did not expressly explain why it concluded that it could count Judge Reinhardt's opinion as the majority opinion, even though it was not endorsed by a majority of the living judges at the time of issuance. But the justification suggested by the footnote noted above is that the votes and opinions in the en-banc case were inalterably fixed at least 12 days prior to the date on which the decision was filed, entered on the docket, and released to the public. This justification is inconsistent with well-established judicial practice, federal statutory law, and judicial precedent. As for judicial practice, we are not aware of any rule or decision of the Ninth Circuit that renders judges' votes and opinions immutable at some point in time prior to their public release. And it is generally understood that a judge may change his or her position up to the very moment when a decision is released. We endorse this rule in United States versus American Foreign SS Corp., which interpreted an earlier version of 28 U.S.C. 46C, the statutory provision authorizing the Court of Appeals to hear cases en banc. The court version of this provision permits a circuit to adopt a rule allowing a senior circuit judge to sit on an en banc case under certain circumstances. But at the time of our decision in American Foreign SS Corp., this was not allowed. Instead, only active judges could sit en banc. See 28 U.S.C. Section 46C, 1958 edition. In American Foreign SS Corp., Judge Harold Medina was one of the 5 active judges on the Second Circuit when the court granted a petition for rehearing en banc. After briefing was complete, but before an opinion was issued, Judge Medina took senior status. When the en banc court issued its decision, the majority opinion was joined by Judge Medina and 2 active circuit judges. The 2 other active circuit judges dissented. We vacated the judgment and remanded the case, holding that an active judge is a judge who has not retired from regular active service, and a case or controversy is determined when it is decided. Because Judge Medina was not in regular active service when the opinion was issued, he was without the power to participate in the en banc decision. Our holding in American Foreign SS Corp. Applies with equal, if not greater, force here. When the Ninth Circuit issued its opinion in this case, Judge Reinhardt was neither an active judge nor a senior judge. For that reason, by statute, he was without the power to participate in the en banc court's decision at the time it was rendered. In addition to Section 46C, Section 46D also shows what the Ninth Circuit did here was unlawful. That provision states, a majority of the number of judges authorized to constitute a court or panel thereof, as provided in paragraph C, shall constitute a quorum. Under Section 46C, a court of appeals case may be decided by a panel of 3 judges, and therefore, on such a panel, 2 judges constitute a quorum, and are able to decide an appeal, provided, of course, that they agree. Invoking this rule, innumerable Court of Appeals decisions hold that when one of the judges on a 3-judge panel dies, retires, or resigns after an appeal is argued, or is submitted for decision without argument, the other 2 judges on the panel may issue a decision if they agree. And there's a whole bunch of case law cited there. Settled law permits a quorum to proceed to judgment when one member of the panel dies or is disqualified, with the exception of one recent decision issued by the Ninth Circuit after Judge Reinhardt's death, but subsequently withdrawn. See the earlier footnote. We are aware of no cases in which a Court of Appeals panel has purported to issue a binding decision that was joined at the time of release by less than a quorum of the judges who were alive at that time. Because Judge Reinhardt was no longer a judge at the time when the en banc decision in this case was filed, the Ninth Circuit erred in counting him as a member of the majority. That practice effectively allowed a deceased judge to exercise the judicial power of the United States after his death. But federal judges are appointed for life, not for eternity. We therefore grant the petition for certiorari, vacate the judgment of the United States Court of Appeals for the Ninth Circuit, and remand the case for further proceedings consistent with this opinion. It is so ordered. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com.